Good morning. Thank you for joining us. We are about to begin our marijuana industry webinar on the implementation of 502. We have a number of people here in the room today at AWC's offices, and we have over 100 and nearly 200 registered watching us in their offices. So thank you again for joining us. We have an incredible set of speakers who will be talking today about the implementation of Initiative 502, legalizing recreational marijuana, and what cities and local jurisdictions should be thinking about and planning for as we are about to see the first licensees coming forward and the rules being adopted by the Liquor Control Board. Today we have speakers from the Liquor Control Board. We have Rick Garza, Agency Director, Alan Rathbun, Licensing and Regulation Director, and Becky Smith, Marijuana Licensing and Regulation Manager. And they'll be talking about the rules process and how the Liquor Control Board will be working with applicants and cities moving forward. They'll speak and then we'll have a few minutes for questions from them afterwards. For those of you who are watching the webinar, you will be able to type in your question. At the top of your screen on the left-hand side, there is a Q&A button. Just click on that, type in your question, hit enter, and we will do our best to answer those questions as we receive them. We are also recording this webinar, so it will be available on our website later, and we will try to compile a number of the frequently asked questions and put those up as well. After the Liquor Control Board speaks, we'll have some perspectives from city attorneys. We've got David Galajian, Assistant City Attorney from Kent, Washington, who will be talking about the history of the marijuana law, federal and state preemption issues, licensing liability, and a number of other things that you'll want to consider. We will also have Phil Olbrechts, Hearing Examiner and Managing Member of Olbrechts and Associates, talking about land use planning and zoning options for cities. And last but not least, we'll have Brennan Staley, Senior Urban Planner from the City of Seattle Department of Planning and Development, talking about sort of the nuts and bolts of zoning and planning and working through that process and what to expect with the marijuana licensing process as compared to the liquor licensing process. So we've got, again, a great set of panelists, I think, for you today, and it's our goal to try and provide as much information for local jurisdictions as possible so that you're as prepared as you can be for this really unique challenge that is coming at us, and something that we're, of course, one of the first in the nation to experience with the legalization of marijuana, and the Liquor Control Board, of course, has been on the forefront of figuring out how to make that work in our state. So with that, I will turn it over to Rick Garza. Thank you.
Thank you, Candace. Good morning. Thanks to AWC. I know we have very little time, and we do have our licensing director and our marijuana licensing manager here. I'm going to give you at a very high level a review of where we are with the rulemaking process, specifically the provisions of that. And then I'm going to try to get through it quickly so it gives you the opportunity to ask questions of us. So obviously the presentation today will look at the objective of the Liquor Board in implementing the new law, our timeline, and then highlights of the rules. Our objective is to create a tightly controlled and regulated marijuana marketplace, including strict controls to prevent diversion, illegal sale and sale to minors, and providing reasonable access to product to mitigate the illicit market. Our role and responsibility, and I think that's why the proponents of the initiative gave it to the Liquor Board, was ensuring public safety is a top priority. Much like mirrored by our alcohol beverage law, it has a traditional three-tier system that we'll talk about. Obviously, it creates licenses for producers, processors, and retailers. We will have not only licensing staff, but marijuana enforcement officers that will enforce our laws and rules pertaining to licensees, just as they do for liquor licensees. And of course, we'll be collecting and distributing taxes So very quickly, I'll walk through the implementation timeline, which, as you know, which you may have learned last week, has changed a little bit. So we're looking at, as you know, coming to the board on September 4th to refile a supplemental CR 102. There have been some changes made, and really what we wanted to do, and we can talk about it within the presentation today, is further clarify some of the production caps that we're going to place on those that produce and process, and then also provide the law requires that we provide by county the number of retail locations. And I think for all of you in the audience today, you'd like to know, what does that look like for my county? What does that look like for my city? And we're going to be more specific in prorating those in the county by city populations. It will look very much like the liquor model that we used when we had state and contract stores under the Liquor Control Board, so that you know what the timeline is. There will be another round of public hearings, likely one on the west side, one on the east side on October 9th. The rules will be adopted on October 16th. They become effective on the 16th. And then what we plan to do is open a window for 30 days to accept applications for all three licenses. As you may recall, the only mandate in the law, the only requirement of the law for the Liquor Board is to adopt rules by December 1st. And then we will begin to issue licenses in March and April. As I said earlier, some of the licensing requirements, and really the rules are broken up into three areas. How do I meet the requirements to be a licensee? What are the public safety provisions in the rules? And what about consumer safety, which is something that we've not had to deal with around alcohol because many of those regulations are federal, but as you all know, there are issues with respect to the federal government. So we plan to use a model that was used in Colorado for medicinal marijuana, which is and was regulated, to allow for a 30-day window for folks to apply. We may extend that time or reopen the application depending upon how many applicants we have. And like I said, we use the same model that Colorado used. Interesting to note that 50% of those businesses folded within 18 days in discussions with the Department of Commerce here in the state. That's not unique. Most businesses, even restaurants in the state, have a pretty high failure rate. But we share that because that has to do with the number of producers and processors that will be licensing originally. Also, as you know, the law has a 3-month requirement of residency in the state. And that really does, when you look more closely at those that apply, will require that people be from within the state of Washington. Background checks. Like that we have for alcohol, there will be fingerprinting of all potential licensees, both in the state and with the FBI, which will do background checks. It's similar to what we do with liquor, and any personal history, as far as criminal that you have to provide on your application, you could forfeit your license if it's incomplete or incorrect. All applicants must disclose the arrests or convictions. And again, as I said earlier, non-disclosure of arrest, regardless of conviction, will result in a point accumulation. And much like we do for liquor, we'll look at convictions more than we will arrests, determine on a point scale whether you qualify for a license. The application, which is in the law, fee is $250, and then the annual renewal is $1,000. There would likely be additional fees for background checks and filing for local business licenses. Another requirement in the rules is that licensee applicants must submit an attestament that they are current in taxes owed to the State Department of Revenue. Now, very quickly, the public safety provisions in the new rules. The board had originally only looked at indoor grows, but changed that in the rules to allow for outdoor grows as long as they meet the requirements that we have in the rules, which I'll talk about in a moment. We just recently went out with an RFP for a traceability model or software that we'll use that all three licensees, whether you're a producer, processor, or retailer, will be required to tie into the liquor board. So in fact, we can trace the product from seed or clone to sale, and then also allows our enforcement to match records to actual product on hand. I talked earlier about the background checks that are required, and there's also a disqualifying point system similar to liquor. Some of the security and safeguards, both for the producer, the processor, and the retailer, alarm and surveillance video camera requirements, strict transportation or record keeping requirements. And the board did change the hours of operation to 8 to 12 a.m. They originally were looking at mirroring our liquor law, but there was concern from citizens and the prevention community that we limit those hours of operation, and the board chose to do that. Violation guidelines, we created a penalty guidelines that are very similar for liquor with respect to marijuana, actually a little more strict than we have for liquor, but we felt that was important to do. Obviously, furnishing marijuana to a minor remains a felony offense. We also got feedback from the original rules that we needed to include child-resistant packaging. That's been done in the rules. And then another area that we got a lot of input on was advertising restrictions. And the law does have a restriction that you cannot advertise within 1,000 feet of the entities that are listed on the PowerPoint, schools, public parks, transit centers, arcades. And that's very similar to the restriction that you can't be within 1,000 feet anyone holding those 3 licenses from the same entities. Now that's something that we don't have for liquor. That's pretty restrictive in that you can't advertise within 1,000 feet of those entities. There was also concern of packaging or advertising being appealing to children. So you see a statement on the second bullet that speaks to that. And then there was also concern that we place on the packaging a statement that the product can be intoxicating and may be habit forming, which we've placed in the rules. One thing that I'm sure you're waiting for is location restrictions as far as retail stores. When we provide the rules on September 4th, we'll provide by county the number of retail outlets and then by city, and that will be something that will be available on September 4th. Then consumer safety aspects of it that we haven't had to be involved in with liquor before because that's done federally, but we worked with the Department of Agriculture and then also looked at the regulations in Colorado with respect to medicinal marijuana. And they're also, as you know, writing rules and a law to allow for recreational use of marijuana and licenses. And we've been talking with each other frequently, and we're using much of the information that we got not only from BOTEC, our consultant, but also from Colorado. Limits on service and servings and concentrations per package, lot numbers, warning labels, net weight, concentration of THC, and then usage warnings and some level of education to the public around infused products and foods that are sold with marijuana. We'll also require that all lots be tested, both producer and processor licensees. We're establishing uniform testing standards. There's also store signage and product warnings. Obviously, the law does not allow anyone under 21 to enter the stores. We're also requiring product and usage signs within the stores. There's no open containers or handling of product, which is what you see today in medicinal marijuana dispensaries. The law does not allow for that. And then we also wanted to define serving sizes for infused products, and you see that we've placed them at 10 milligrams per serving, 100 per product, similar to what's used in Colorado. Also want to continue to share with folks that you can go to our website. We've got an I-502 icon there on the front page where you can get information on where we are within not only the rules, but in implementing the new law. There's also a listserv there. We have over 6,000 people signed up for that today, but you can get the information that you need. If there are questions with respect to licensing, there's contact people on that website. I also want to give Alan Rathbun very quickly an opportunity to share some additional information that I think you might be interested in. Alan.
Thanks, Rick. Just a brief comment. Very soon you will be receiving a notification from our offices requesting point of contact information. As in liquor, when we receive an application and at time of renewal, local authorities are given the opportunity to submit objections to those applications, and we want to make sure that we have the right point of contact. So we are going to be sending a request out to all our local jurisdictions, asking them for that point of contact. Also asking for any ordinances that these local jurisdictions may have which may influence the ability to locate any of the marijuana licenses within that jurisdiction. And then finally, once the rules are adopted, we plan on trying to conduct some regional workshops and invite local governments to those to have a conversation with, excuse me, with licensing staff about the process of submitting objections and what that whole process looks like on the liquor, on the marijuana side as it compares to liquor. So with that, we'll open ourselves up for any questions.
Should I identify myself? Or my name's Darren Neighbor. I'm an attorney in the city of Olympia. We had some difficulty identifying trails that meet the definition of the rules. There are trails defined by our regional transportation planning agency, trails in our comp plan, and then trails listed by our parks department in their planning documents. Will there be any additional clarity in that?
There is going to be some additional clarity relative to definitions on those buffer areas in rules that will be coming out. So I think you will see some additional clarity there around those definitions.
Ellen, can you just repeat the
question? Oh, I'm sorry. I forgot to repeat the question. The question from the city of Olympia pertained to having difficulty trying to identify trails and within jurisdictions as to they may relate to that buffer from a standpoint of where locations of licensed places can be. And my response was that we have heard some of those concerns, and there is going to be some clarifying language in the rules that will be proposed and going to the board for approval on September 4th.
And we had a question from somebody on the webinar asking, can cities adopt hours of operations that are more strict than the Liquor Control Board's hours?
I recall that there is a provision in the rules regarding liquor in which they can local jurisdictions can in fact adopt regulations as long as they're consistent across there. I do not believe we have that provision in our proposed marijuana rules at this point.
Yeah, this is Rick. I don't know that we do. It's a really good question that no one's asked. So, I mean, it's a pretty practical one, actually. So I think we want to go back and take a look at that. I think if they're reasonable hours, I mean, I'm not sure that you don't have the ability to do that, but we'll look at that and provide comment back. I don't know if we do that directly through you, Candace, so it gets back to the group, but it's an interesting question, and we haven't been posed before. Thanks.
If you can give the information to us, we'll make sure it gets out.
Yeah, let me ask also, the gentleman asked about the trail. Tell me why a concern, or how do you see that as part of the rules? Is it the 1,000-foot buffer that you're concerned about? Because I think originally what we've talked about, and we'll clarify it in the next 2 weeks, is we don't consider a trail a park. And so if there's a trail, and I think we need to be very clear with you, and I think that's what we're trying to do in these rules with respect to the definition of those entities, because we're getting into what if it's a private park? What if it's a park held by a group of homes, you know, or so I think we're trying to be more clear that we're looking at public parks. We wouldn't consider a trail a park, and so it wouldn't be part of the definition within 1,000 feet, because I think when we get down to doing that measurement, which we will do a physical measurement of, and we've determined that we probably need to do that, especially initially, rather than relying on GIS. And we'll try to be very clear about, from the point of the licensed premises to the grounds of the boundary of the entity that has the 1,000-foot buffer attached to it, that we'll try to be more clear about what that looks like. But I think you make a good point, and I'll share with everyone, is we're trying to be very definitive and clear about what do those entities mean and who apply, what parks apply and what parks don't. So thanks for the question.
So we have a few more questions from folks on the webinar. a couple of people have asked a similar question about how will the Liquor Control Board ensure the 1,000 feet separation, and are local jurisdictions responsible for providing information to determine that 1,000 feet separation? So those are two related questions. You can address that.
Can I answer for that?
Well, relative to the 1,000-foot buffer, that burden will lie with the Liquor Control Board from the standpoint of whether or not someone qualifies for a license. So we will, to the degree required, make that physical measurement. Then, if in fact it is within 1,000 feet, it is a process whereby the board would have to seek denial and give the applicant the right to due process and before an administrative hearing. So even though it's a relatively strict measurement, just like we do in liquor, we would have to go through a intent to deny process and grant the applicant due process, but would be the burden of the Liquor Control Board to be able to bring that issue.
Some related questions that are coming in through the webinar. How robust is Liquor Control Board's database of local parks and other sensitive receptors that are subject to the 1,000-foot limitation?
Yeah, that's a good question. I think that's why ultimately what we've learned in the last month is we'll do a physical measurement, because any GIS system that's out there or any kind of Google software that's out there, whether it's current or not, is always a question. So I think initially, Candace, what we're looking at is literally taking someone out there to do a measurement so that we know that we're close, because we wouldn't want to allow for a license and then learn later that in fact they're within the buffer.
And that's true, but I will say too that we have started reaching out with our IT staff to local jurisdictions to try and gain where they have GIS data around locations that are within their jurisdiction, because we're going to try and gain that information, but maintenance of that information at the state level is going to be extremely difficult. So I think that we're going to have to rely in large part on physical measurement as well.
We're also getting a few questions, and I'm going to try and kind of lump a few together about definition of public park. And there's some concerns about the current definition of public park, and does it include port-owned property? Would the interurban trail be considered a public park? And and will that definition of public park be expanded to include other properties beyond just what's currently in there, which I think is state, federal, and locally owned parks?
Like I said, I don't believe, I believe we looked at some issues about issues like metropolitan districts and other sorts of things, but as Rick stated, the issue of trails, as I believe, will probably not be included as a park. But we have tried to expand that definition based on comments to include kind of the regional sort of things that weren't maybe state, city, or federal in relationship. So we did try and include some language to clarify that as well.
And then maybe one last question, and then we'll move on. And for folks at home or in your office, you might be at home, we will continue to collect your questions, and we'll have a lot of time at the end for question and answers as well. But the question here is that the Liquor Control Board likely won't have any information on daycares within 1,000 feet. How will you account for daycares?
Well, we are utilizing information from Department of Early Learning, who is the licensing entity for daycares, and so that information will be available to us because I think we're referencing state licensed daycares, not daycares that are in fact just not a regulated entity. I also know, though, that there is some concern, and we have to be concerned with the confidentiality of those locations as well. So as far as sharing that information, we're working through interagency agreements with our other state partners in collecting and maintaining that information.
Okay, thank you very much. And again, we will have additional time for more questions. I know there are a lot coming in through the web right now, and we are collecting those and We will be asking those after our next set of speakers. And with that, I will be inviting up David Galatian from the City of Kent. Thank you.
Thank you. So one of the reasons I chose Gordian not to represent where we find ourselves, it was something that was considered unsolvable and kind of a test of intelligence and wisdom. I'm hoping that for cities, other local jurisdictions trying to work with the state and within federal parameters, that it's not ultimately unsolvable, but it has certainly been trying so far. Right now we have three different competing interests, and we've got the federal government, we have the state, and we have a bunch of cities and counties standing around trying to figure out who's going to make the first move. Under the Federal Controlled Substances Act, of course, marijuana is classified as a Schedule I controlled substance. It's got a high potential for abuse, no accepted medical use, and as a result, it's unlawful to manufacture, distribute, or possess. Now, under I-502 is a state license scheme to manufacture, distribute, and possess. Now, we have local cities. They have a general right to control the kinds of businesses that operate as well as the locations. So they're kind of stuck unwillingly and to some extent in a position of trying to figure out what to do. Just a little background with the medical marijuana. Like federal law, Washington has a Controlled Substances Act, and marijuana is listed as Schedule I. However, in 1999, legislature adopted RCW 6951A, the medical marijuana, which created a limited affirmative defense. It was amended a couple of times, and then in 2011 session, the legislature passed the Engrossed Second Substitute Senate Bill 5073, and that was an attempt to create a licensed marijuana industry where it'd be run by the state, Departments of Health and Agriculture. So it'd do licenses for producers, processors, and dispensers. It included a provision for a secure registry for patients and licensees. And it also had a secondary provision to allow patients to jointly grow cooperatively without licensing. And that was the section on collective gardens. Now, of course, most people are probably aware the U.S. Department of Justice sent a warning letter to the governor prior to her signing the bill, warning that there could be consequences if it was passed as completely as it was by the legislature. One of the things that they pointed out was that the bill would create a licensing scheme, it would authorize conduct contrary to federal law, undermine government efforts to regulate, and it involves state employees who would be undertaking activities mandated by legislative proposals. And under that, they might not be afforded the general liability they otherwise would have under the Federal Controlled Substances Act. So of course, acting on this, the governor decided to veto and gut most of the sections that created a license scheme as well as the registry. What was retained, Section 403, which allowed for collective gardens, Section 1102, which allowed for local authority to regulate, and it still maintained that being a qualifying patient was still only affirmative defense. Thus, it still remained illegal under state law. And of course, we had Initiative 502 come through, giving the people the power to decide whether or not to take that further step for being a limited affirmative defense towards actual legalization. So I-502 was similar to what 5073 was going to intend. It's got an industry licensed by the state, that's not going to be by the Liquor Control Board. There was a 1,000-foot buffer from certain uses, as the board was explaining. There are certain youth-oriented uses, such as schools, playgrounds, daycare, arcade games. And there's also community-oriented gathering spots, such as libraries, parks and recreation facilities, and general transit centers. Now, 5073 did allow local regulation, and I think some of the other speakers are going to talk a little bit more about that. However, notably, I-502 is completely silent on whether cities have any kind of zoning authority, other kind of land use. It just doesn't mention it at all. There is one provision in that speaks to the Liquor Control Board adopting rules relating to retail outlet locations and hours of operation. But I think regarding one of the questions that came in, whether a city has the power to further restrict the hours of operation, and it seems to be from the liquor standpoint in alcohol beverage industry, that was indeed the case, and that's a good thing that I hope the Liquor Board is going to look into. But also the locations, just the fact that rules may describe locations wouldn't seem to take away municipal authority, because the Liquor Control Board is the one who's designed to try and figure out where these retail locations are going to be by county, working with OFM by population. So mainly what I want to talk about are federal, state, and preemption issues. Under the Supremacy Clause, Article 6 of the U.S. Constitution, the federal law is the supreme law of the land, and where state and local law conflicts with federal law, basically there's preemption. Now this is hardly an easy question to figure out. There's a general presumption against federal preemption when you're looking at areas that are traditionally powers that belong to the states or powers that were exercised by local jurisdictions, such as land use and zoning being very clearly traditionally local power. There's four types of preemption. There's express, field, obstacle, and conflict. Some courts look at obstacle and conflict being just two prongs of the same type, but I think it makes it easier to break it down into four. The main point in looking at the types of preemption issues are looking to congressional intent, and that's really what drives all of these. So under express preemption, that's where the Congress has spoken directly on point and said that they preempt certain parts or all of the field. Field preemption is a little bit different. It says where Congress hasn't spoken to it directly, but it can be implied that Congress has adopted a comprehensive scheme so pervasive that it's a reasonable inference that Congress left no room for concurrent jurisdiction. Now, when you get to obstacle preemption and conflict preemption, it gets a little bit more difficult. Under the analysis for obstacle preemption, it's where state or local law stands as an obstacle to accomplishment and execution of the full purposes and objectives of Congress, which obviously is not an easy question to answer either. It involves looking at the totality of the circumstances and looking to see whether a statute or ordinance would frustrate the implementation of a federal act. Conflict preemption really has been broken down into a physical impossibility of dual compliance, where it's a pretty tough one. Courts have often looked at the possibility prong and said, well, it's easy for somebody to comply with both laws at the same time if one law prohibits and one law allows it by doing nothing. Therefore, they're in compliance. So the Controlled Substances Act has a section that says no provision shall be construed as indicating an intent of Congress to occupy the field to the exclusion of any state law on the same subject matter unless there's positive conflict so that the two cannot consistently stand together. Supreme Court has looked at this and said it shows that Congress explicitly intended a role for state laws in this area and disavowed an attempt to completely occupy the field. Most courts that have looked at this have said, okay, for these issues, state laws that deal with marijuana won't be generally analyzed under express or field preemption theories. So that leaves the conflict and obstacle preemption. So the positive conflict is where, as I said, the state law requires what a federal law prohibits or prohibits what a federal law requires. Because it's got that mandatory language to it, it's been relied on very rarely, and it's been seen both by the Supreme Court as well as other state courts as a pretty limited window. But keep in mind it's important about the required prohibited element to it. Now, looking at preemption as far as obstacle preemption, there's obviously a lot of case law that's gone along the medical marijuana side, and none that really deals with the legalization. So California has been dealing with medical marijuana for years, and thankfully there's been a wealth of case law that's gone along, and it just recently got to the state Supreme Court level. Oregon also has had a chance to look at this. One of the cases that looked at obstacle preemption is Pack v. City of Long Beach, which is a California appellate case. But it's this one where the court considered an ordinance by the City of Long Beach that was attempting to welcome in dispensaries, adopt a comprehensive regulatory scheme, the permit system. Dispensaries submit applications along with fees. They would enter a lottery for licenses. City would then issue permits. Only people with permits could operate, and there would be an annual regulatory fee, which started at $10,000 and went up from there based on the size. The California Appellate Court looked at this and said, this goes beyond simple decriminalization, and the ordinance by the city actually authorizes the collectors to cultivate marijuana. They cited the Supreme Court case of Michigan Canners and Freezers of the Agricultural Board, which contained a statement that a law that authorizes people to engage in conduct that the federal act forbids stands as an obstacle to the accomplishment and execution of full purposes and objectives of Congress. Emerald Steel Fabricators, an Oregon Supreme Court case, a little bit different. This is an employment case. A temporary steel worker was let go. He was being considered for a permanent position. He was an authorized medical marijuana user, formed a supervisor of that fact, and he was fired. He filed a discrimination complaint for failure to make reasonable accommodation, and the issue was under state law whether or not he qualified as being under the illegal use of drugs. If the Oregon law could be interpreted as affirmatively authorizing the use of marijuana, then it wouldn't be an illegal use of drugs. So the Oregon Supreme Court, again, dismissed the impossibility argument and looked at whether that state law, the medical marijuana law, stood as an obstacle. So they also cited the Michigan Canners case, but what the court boiled down to was the purpose of Congress, as they said, was preventing all use of marijuana. So a law that authorized that use would mean that Congress couldn't achieve that goal. Now, that was what the majority held. There was a fairly compelling dissent that goes along with it, and it argued that the Oregon medical marijuana law didn't purport to grant authority to violate the federal law in order to affect federal enforcement of the Controlled Substances Act, and argued that the Michigan Canners case actually involved a federal law that created a right, and the state law in the Michigan one, which is, it involved canners unrelated to marijuana, was something that prohibited free exercise of that right. A state could decide to permit citizens to engage in licensed activity and just run the risk of federal prosecution. One of the things that the dissent cited was a statement by Justice Brandeis made in dissent about the applicability of federalism, where allowing states to decide amongst themselves which conduct might be beneficial and something that was novel or useful, and consider the fact that a state could adopt different laws from the federal government be a chance for it to be a laboratory for a novel or social change. Going on to state preemption, so that would be the issue of whether a local or state law would be preempted by the federal law. I can kind of come back to that in a bit. State preemption, under Article 11, Section 11 of the Washington Constitution, a city may make and enforce within its limits all local police, sanitary, or other regulations not in conflict with general laws. Ordinances acted pursuant to a local police power generally enjoy a presumption of validity unless they're proven unconstitutional. They can be considered unconstitutional when preempted by state law. Washington generally looks at two types of preemption, either field preemption or conflict preemption. The field preemption for Washington is whether there's an express legislative intent to preempt the field, or if the intent is implied, they can enroll them together. And where a statute provides some measure of concurrent jurisdiction, express legislative intent is absent. So as far as the Washington Controlled Substances Act goes, 6950, it has a preemption provision in there. And now I-502 has been codified largely in 6950. The Washington Supreme Court looked at this in Tacoma v. Levine and said that because the legislature affirmatively expressed the intent of concurrent jurisdiction for municipalities, it said that local laws and ordinances that are inconsistent are preempted, but that therefore meant that local laws and ordinances that are consistent would be permitted. So there is no, arguably no express preemption within 6950 that I-502 would follow. And it doesn't appear from a reading of the initiative itself that there is an expression of intent to preempt the field also. So we would look at implied preemption. Now to decide on the implied preemption issue, Washington Supreme Court again has stated it won't interpret the statute is taking away or removing municipal power unless there's really clear legislative intent. If we look at the intent of I-502, among other things, the fact that the Liquor Control Board is regulating it, the intent is to mirror existing liquor laws to a large extent. Now, state law regulates the industry of alcohol beverage, but it does not disturb local police powers generally. And so I think the most clear argument is that there is no implied intent either in I-502 to preempt state authority. However, that still leaves the possibility of conflict preemption. This is where, under state, it's a little bit different. It says where there is a direct and irreconcilable confliction with the state statute, and where an ordinance permits what the state law forbids or forbids what state law permits. Now, this is different from the federal context, which is mentions a required activity. This is only permissible activity. So arguably, it's a different standard. Again, ambiguities are supposed to be resolved in favor of harmonization. The courts have said repeatedly when looking at preemption issues in Washington, not involving marijuana, but other local ordinances that go hand in hand with statutes. And they've said, for example, the fact that an activity may be licensed under state law does not lead to the conclusion that it must be permitted under local law. There's also a presumption against state preemption where significant local interests vary. This is important, and we get back to marijuana. There actually was a case, the Inland Empire case that came out of the California Supreme Court, was a situation where a city had prohibited dispensaries, and the dispensary owner argued that that ordinance was preempted by state law, allowing these collectives. So a lot of cases have been looking at this to the appellate level. The Inland Empire case gave the California Supreme Court a chance to consolidate and address this. They held that municipalities still have the ability to prohibit, even though the state permitted, state law permitted these collective operations. One of the significant things it mentioned in the decision is that when there are significant local concerns that may vary between jurisdictions, a presumption against preemption is supported, because you want to look at whether or not it was intended that there was a one-size-fits-all sort of application. There's a couple of cases. So moving on I'll kind of touch on this briefly because I want to make sure everybody has a chance to go. As far as business taxes, obviously the I-502, they're subject to the excise tax at 25% at each level. Also explicitly states that retail sales of marijuana are taxable under local, state, and use taxes. So generally, a city could have, a business occupation tax that would apply to all three levels. However, they could not have a special sort of marijuana tax. If you look at business licensing requirements, again, the city is going to be involved in a lot more if they decide to regulate the industry than just providing different zoning options for it. And these raise a whole host of concerns. If you're collecting tax money for this operation, does that start to implicate federal law? If you are requiring somebody to fill out an application, does that start to implicate Fifth Amendment rights because the activity still remains illegal under federal law? As far as filling out applications and taxing authority, the Supreme Court has been pretty unequivocal that for federal tax purposes, the fact that you conduct illegal activity doesn't mean that you don't have to file a tax form and still fill it out, but that doesn't implicate Fifth Amendment concerns. A recent Ninth Circuit case says that Fifth Amendment privilege cannot be invoked to resist compliance with regulations that are unrelated to the enforcement of criminal laws for general businesses that apply equally. The other issue here is whether or not there is immunity for government employees. There's been some cause for concern, as the Department of Justice pointed out in their letter, that activities that are still illegal under federal CSA would be considered illegal, and normally state or government local employees who are involved in activities that regulate and enforcement of laws that speak to controlled substances enjoy immunity. However, they've said that if the law that's being enforced is not consistent with the federal law, then that immunity doesn't apply. The local interaction with the Liquor Control Board, I think they did a great job explaining how it's going to go, and they're going to be presenting some more information in the future. One of the things I just want to touch on is it's going to be important for cities to look at some of the issues that have been raised today. For example, if an application comes in, the burden is indeed going to be on the Liquor Control Board to determine the 1,000-foot buffer, determine what these uses are. However, there may still be some ambiguity over, for example, what is a park. And cities should have a role in trying to inform and be part of that process. The Liquor Control Board obviously isn't bound by zoning, but I think cities need to be able to work cooperatively and provide their own analysis on the issue. So there are possibilities in front of us. We're just not sure. A local ordinance could be in conflict with I-502 if a local jurisdiction tries to prohibit it. The question is, would that be preempted by state law? Local regulations could conflict with the Federal Controlled Substances Act, and then I-502 itself could be conflicted. Courts, the state courts that have looked at marijuana issues have tried to favor coexistence where possible. However, I would just say in closing that the preemption issue regarding federal preemption is probably strongest if you look at a situation where a city may be forced into taking action that it might otherwise legislatively argue against. So that's an area that just hasn't been addressed yet.
Okay, thank you. We have one question for you, specific to preemption from the web, and it is former U.S. Attorney John McKay believes that there is no conflict preemption because there's no, under the state licensing scheme, there would be no interstate commerce that would nullify federal jurisdiction. Can you address that?
Yeah, the Supreme Court has said pretty clearly in recent case law that even the completely intrastate commerce of marijuana is still subject to congressional authority under the Commerce Clause because it still touches and bumps up against the illegal drug.
Hopefully we're back, and folks watching the webinar, you are with us again. Sorry about those technical difficulties. Seems like you can guarantee there will be some kind of technical difficulty. There were a few questions that David was answering during that time, and we will come back at the end and try and recap some of that and address the rest of the questions that are coming in online. Right now, though, I'd like to turn it over to Phil Ulbricht to give us his perspective on cities' options.
Thank you, Candace. Well, as Candace mentioned, I'm a land use attorney, so I have to talk about marijuana zoning. And dealing with this issue is kind of like dealing with the really twisted and sick form of let's make a deal, okay? Behind curtain number one on this PowerPoint slide here to your left is the option of adopting regulations that authorize marijuana in your community, and that assumes the risk then of yourself being arrested for violating the Controlled Substances Act or your city or county employees. And I don't know, maybe that's a future shot of a liquor control board member there under arrest. That's one of the things we have to deal with when we authorize these type of uses. Curtain number two, your other sole option on the right there, is to adopt regulations that prohibit marijuana altogether, and that runs the risk of violating state marijuana laws, and because of that, your marijuana regulations could be invalidated, and you could also be subject to damages suits for violating the constitutional rights or even statutory rights of people who want to engage in some type of marijuana business. And really, curtain number three, which isn't on this slide, is simply a combination of those two. I have to tell you that in representing cities as a city attorney, and now I do some hearing examiner work too, in over 20 years, I've never actually had to go to my clients and say, well, which law are you most comfortable in violating? Because that's kind of what we have to do here. We have a balancing act of assuming and weighing these legal risks. And actually, when it comes to dealing with zoning for marijuana, I think there are three primary factors. One is, you don't want to get sued for violating federal law, and maybe I should say you don't want to get prosecuted for violating federal law for allowing marijuana. Of course, two is you don't want to get sued for violating state law. And three, of course, very important, and especially to this AWC audience, is, do what the constituency wants. And a lot of the time, that third one is ultimately going to dictate how you balance those first two factors. And I just have to tell you, except for three really limited circumstances, you're not going to be able to meet all of these objectives. You're going to have to compromise on at least one of them. And that's what makes this whole situation so tough for us all. I think the three circumstances where you may be okay, one is kind of implementing the do nothing option, okay? Your community embraces and loves the fact that marijuana is now legal, and they want to have it, and they don't mind seeing dispensaries in the commercial zone. They don't mind people growing marijuana in the backyard or some big collective operations out in the ag zones. And as I say, your regulations allow it. They don't involve any type of discretionary permits where you involve yourself in a lot of review and authorizing these kind of things. Under those circumstances, you're probably not going to violate state or federal law. There's still a little problem with federal there. You'll probably okay. The other sort of luck factor or luck situation where you'll probably be okay is if you're just a bedroom community that just has residential zoning. And in that circumstance, if your constituents don't mind the fact that some people might be growing a little marijuana in their backyard, you'll probably be okay there as well. They're probably, with all the arguments about whether or not a complete ban on marijuana is valid, if all you have is residential zoning, I don't think any court's going to say you have to, allow commercial operation in that kind of circumstance. The third situation where you'll probably be okay is if those separation requirements from I-502 work out for you. I mean, really, one of the first things you want to do when you look at your options for dealing with marijuana zoning is to see how those 1,000-foot separation requirements apply to your community. And to be more specific, you can't be operating any business regulated by 502 that is within 1,000 feet of schools, parks, recreation facilities, arcades, those type of sensitive uses. And in some really small communities, it could turn out maybe that the only place left to cite these things is in an area that nobody in the community cares, or maybe there isn't even any space really left for that, and you'll be okay there as well. But the rest of us, though, we have to look closely at these factors to figure out, how it applies to us and what risks we want to assume. Don't violate federal law. That's the first objective. I asked David Galatian if he would. I tried to pass this off on him, and he said, "Well, that's not in my area of expertise," and that was a wise thing to do, because I think any discussion of what kind of acts are going to subject you to criminal prosecution under the Controlled Substance Act, it's a really speculative discussion at this point. I mean, no, at least to my knowledge, and please correct me if anyone in the audience knows the contrary, no state official has ever been arrested or prosecuted for implementing a state's marijuana law, whether it be in the state of Washington or anywhere else. Okay, there's no case law on this kind of thing that directly addresses it. We really don't know ultimately what's going to happen. So nobody's really qualified to tell you with any degree of certainty, concretely what risks you're subjecting yourself to by allowing marijuana and by licensing it and that kind of thing. But we have a couple clues, though. One is a Department of Justice letter, actually it's from the Drug Enforcement Agency, to Clark County. Now, David, in his presentation, mentioned the fact that, Governor Gregoire had vetoed most of the provisions adopted in 2011 for medical marijuana because she had conferred with the Department of Justice, and they said that, state employees could be subject to prosecution if they implement, these medical marijuana measures. Well, the Clark County Board of Commissioners, at the time had a moratorium on collective gardens, kind of the only part that's left standing for medical marijuana in terms of any kind of business activity. And it was about to expire, so they sent a letter off to the Department of Justice and says, really? Are you really going to prosecute people for violations of the Controlled Substances Act if we were to allow and license collective gardens? And I think a lot of people have seen this, but it bears repeating. The part of the letter that is a little bit alarming states, anyone, and this is from the Drug Enforcement Agency, anyone who knowingly carries out the marijuana activities contemplated by Washington state law, as well as anyone who facilitates such activities, is subject to criminal prosecution as provided in the Controlled Substances Act. And note the word facilitate such activities. That theoretically could encompass licensing and maybe even adopting regulations. That same conclusion would apply with equal force to the proposed activities of the Board of Clark County Commissioners, again, licensing and regulating those collective gardens and Clark County employees. In addition, the Controlled Substances Act provides for forfeiture of all money derived from such activities. So, maybe the permit fees that you collect and that kind of thing, they can get that back because it was derived from an illegal activity. Again, nobody has been arrested yet at this point, but the Drug Enforcement Agency, who probably likes to arrest people, has said, you run a risk of getting yourself in trouble for doing this. I think maybe even more a little alarming than this particular letter was an Attorney General opinion that it was issued in January of 2012 out in the state of Oregon, where we got a little more concrete example of how this could pan out. In the state of Oregon, their medical marijuana laws provide that if medical marijuana is seized from someone who is in lawful possession under that state's laws, it has to be returned by law enforcement to the qualified possessor. I don't know what the technical term is down in Oregon for the person who's allowed to have it. But anyway, the question was raised and sent out from the captain of the state, Oregon State Police, to the Attorney General's office there, State Attorney General's office. Are we going to be violating federal law if we return this marijuana as required by our state law? And the conclusion of the Attorney General in that opinion was that yes, you would be. And he said, or at least there's a risk, he said, and he said because of that, don't return it. He said only return it if you get a court order to do so, and if you do get a court order to do so, appeal it as far as it'll go. So that's how seriously, he's taking the threat of prosecution down in Oregon. Of course, we're dealing with, that's Oregon laws as opposed to Washington laws. But, what was most paramount in that analysis was federal preemption and the fact that under some Oregon cases at that time, back in January 2012, it looked like that Oregon's laws were largely preempted by federal law, not valid, and therefore, worrying more about federal violations than state. So, when you're making that balancing act of authorizing versus not, consider, I mean, this is somewhat of a serious threat. Again, it just seems politically, I just can't see that there are going to be city council members serving jail time for adopting separation requirements for collective gardens. But it's there, unfortunately. And, there's a lot of information, especially on the Municipal Research Services site, about, the legal consequences of these state marijuana laws. But it is interesting to note, though, that there's very little or almost no information on whether or not you're violating federal law. And, of course, that's still one of the issues you have to balance. So, it's something to know about. And the little information that's out there, and it is speculative, basically kind of provides that if you're actually licensing, you're actually engaged in scrutiny of what the business operations are doing, say, for a conditional use permit, all right? I'm sure a lot of you know what a conditional use permit is, where you have to consider the impacts to adjoining uses, and you have to hold a public hearing, and all this kind of thing. If your zoning code has a provision like that that requires some kind of public hearing process and scrutiny of the illegal activities of this business, and then you authorize it, that's probably one of the riskiest things you can do under your zoning code. And whether it really is risky, that again, subject to high debate, but that's on one extreme of the spectrum. The other, I think, is if your code simply says, in your commercial zones, anything similar to a pharmacy is allowed, and through that you allow medical marijuana dispensaries. I mean, your code doesn't mention it, and the city isn't issuing any building permits or anything like that because they're going already into a building that's already there. Your liability is real minimal there. The next step probably is when you are issuing building permits, because the building code official does need to know what kind of activity is being conducted in that building in order to figure out what occupancy is, that kind of thing. There's a little more argument that the city's authorized it to occur. You can see sort of the spectrum of how this works. All right, now we're in an area of law that I'm more comfortable with is, don't violate the state law. What are the consequences if you adopt a ban or a moratorium that just keeps going on and on and on? Well, the most direct result, if our state laws, survive a federal preemption challenge, and also if our state laws are interpreted to prohibit bans and long lengthy moratoriums on those regulations, then your regulations will be invalidated. And the problem with that is that if your complete ban is invalidated, the person who's suing you, who filed a complete building permit application or conditional use permit application, has vested to your regulations without that ban, which means that if the zoning provisions that still survive allow that use to be there, it'll be allowed to be there. So in effect, by adopting a ban, you're taking a risk that people can build anywhere they want, almost, as long as it's consistent with the other parts of the code. It's the same scenario we have with adult entertainment. A complete ban would be unconstitutional, therefore you might as well just let them build wherever they want if that's what you're going for. The second prong of concern when you're dealing with moratoria and bans is damages, actually. All right. If state law is held up and it's not subject to federal preemption, these businesses could have some kind of a takings claim against you if you have a moratorium that goes on for an unreasonably lengthy period of time. And I'll be talking a bit more about that when I get into the options. And this is a kind of a unique situation that arose out of the state of California, where if you authorize a particular business to be located in a spot and then you change your mind later, say, your interim regulations expire and you decide there are other locations better to place these businesses, and then you tell the business that was there, you got to leave, we'll give you 180 days to leave, that could create some damages for you as well. There was exactly that situation in Santa Barbara, where they initially allowed this marijuana business to open up shop, and in reliance on that, the business spent a bunch of money, putting together its business, and then the city decided, we actually don't want to allow, marijuana businesses in this part of the city, this medical marijuana actually, so get out in 180 days. And they got sued, and they extended the amortization period, the get out of here date to 4 years. But the court still basically said, there's a claim for damages here. This isn't going to survive this dismissal motion, I think was what was occurring in that case. We'll look at the damages because there's this constitutional due process, right, that was violated by the fact that this person, this business expended a lot of money on reliance on these regulations that said that they could set up shop here. So there's also that to consider. You can't be too, again, this California law, very different vesting rights and all that kind of thing down there, but there is that argument to be made if you're sitting there telling this business, go ahead, go forward, you got the green light and spend $1 million on your operations, and then a month later say, actually, no, you can't be there. That's could create some problems. Now, the third objective here, I don't need to actually say much about, and that is make the constituency happy. Those of you in the audience who are elected officials especially are much more knowledgeable about how to do that. But I do want to quote from a newspaper article that came out on Obama's birthday, mind you, August 4th, that basically kind of, highlights the significance of your choices. This article addressed, how cities are addressing the ambiguities of their position on marijuana and zoning. Hesbergard, the marijuana attorney, said his advice to entrepreneurs is to look for sympathetic jurisdictions. He advised staying away from Kent, which bans marijuana businesses, he said, and entering a city like Bellevue with caution. Bellevue, which has resisted medical marijuana dispensaries, has just begun considering zoning regulations for legal pot businesses. A quote from Mr. Hesbergard, they may have restrictive zoning, but I doubt they're going to zone it out completely, unquote, he said. So, if you're a Bellevue City Council, maybe some people in your community are not going to be happy that, that this is the advice that's being dispensed to potential businesses because they're allowing it in Bellevue but not in Kent. And obviously that's a political choice, and it's, I think this article kind of, highlights the consequences pretty starkly. I got to skip some slides real quick because, as usual, I'm not going to be able to finish in my allotted time. My niece has made these little pictures. I think she's from the East Coast. She's real excited about what Washington's doing out here, obviously. But one slide I did want to focus on before I get to your options in zoning, dealing with, where zoning authority comes from. Kudos to the Liquor Control Board. One of their proposed rules, 314-55-0-2011, specifically addresses the authority of cities to zone, and that provides that the issuance or approval of a license shall not be construed as a license for or an approval of any violation of local rules or ordinances, including but not limited to building, fire code, zoning ordinances, and business licensing requirement. So what this rule says is that even if we're issuing a license for a part of the city where this use is not allowed, that doesn't mean that you can build there. You still have to comply with the local jurisdiction zoning. So, I don't think for both medical marijuana and recreational marijuana, and this is for recreational marijuana, the one that's quoted on the PowerPoint here, that there's much debate about whether or not you can restrict locations and impose separation requirements and that kind of thing. Well, there might be some debate about whether you can make it more than 1,000 feet for recreational, but most of your zoning authorities retain. The outstanding issue, though, is can you ban it altogether? And there's a lot of disagreement on that one. So let's move on to the 5 options for zoning now. And this deals essentially with the types of ordinances that you can adopt. And I will say now, I was just reading an article at the MRC website last night and saw an article that contained almost exactly the same options in the same order without the permanent ban option. So I want to give her some attribution because it's a really excellent article called Marijuana Uses Local Regulations by Carol Morris. If you want more information on the issues that I'm discussing, go on the website, look at her. She even has a model ordinance on, I think it was collective gardens and medical marijuana. So it's a really informative document. So if you need more information on this topic, that's the place to go. So anyway, these are the types of ordinances you can adopt, and I'll go through each one fairly quickly. The do nothing option, as I mentioned before, this could actually be the most legally defensible route to go. I mean, if I'm just looking at it from a purely legal standpoint, that's the route I would choose as long as, there wasn't a de facto ban in your code. And what I mean by that is that, your zoning codes, unless you've amended them recently in response to this marijuana regulations, doesn't mention marijuana. Obviously, it wasn't, considered legal until fairly recently. So the way that zoning codes usually work for unspecified uses is you'll have a provision in the zoning chapter on uses that says that, okay, if the use isn't specifically identified in this code, then that use will be allowed in zones that allow similar uses. Okay, and as I mentioned before, then if you have a provision in your code and you allow pharmacies or methadone clinics in a certain part of the city, they conclude, okay, this marijuana dispensaries are most similar to those, so we'll allow those in the same zones. As I mentioned before, if you're good with that, if your constituency's all right with that, you're probably in pretty good shape. your biggest problem are going to be the collective gardens, all right? And the reason why is that, there's a little disagreement about this, but I think most people agree that all the licensing and regulations that the Liquor Control Board has put together only applies to the recreational marijuana, not to these collective gardens. So they're virtually unregulated. They're regulated as the size, up to a maximum of 45 plants, a maximum of 3 persons who participate in them. But that's it. There's no separation requirements or that kind of thing. So if you have agricultural districts in your city, you could have, somebody say, oh, I have, 50 separate collective gardens that just all happen to be right next to each other. And there are games like this that can be played. And, I would think if you wanted to regulate one thing, in your zoning code, it would be at least some kind of separation requirement for collective gardens if you don't want to be faced with the prospect of having a bunch of collective gardens lumped together in your ag zone or something like that. If you don't have an ag zone, you probably don't have to worry about it because large scale agricultural operations probably aren't allowed in your residential zone or your commercial zone. Okay, so when you're analyzing the do nothing option, actually when you're analyzing anything, the first thing, any option is, first thing is, as I mentioned before, see how that 1,000-foot separation requirement. The second is, again, look at your zoning matrix, your table of uses, and see, what's allowed, what's not. And the third tip, never forget, because this is kind of a backdoor way of getting into zones when you were thinking about it, is your home occupations, all right? Every jurisdiction has very different requirements on home occupations. In general, they basically say you can do a home occupation, a business within a single family or a multifamily dwelling, as long as people from the outside don't notice it's there. That's the gist of it. But some communities actually say if you get a conditional use permit, you can actually have people come in and buy things, and you can have a sign outside, this sort of thing. So, when you're considering the do nothing option, always make sure you look at your home occupation provisions and figure out what's going on there. And finally, under the do nothing option, as I mentioned, I think your least liability is if you don't have any discretionary permits involved. Again, these would be your conditional uses, special use permits, even shoreline permits, that kind of thing. So, look at your code. If marijuana is going to be authorized because it's the same as a pharmacy, and for some bizarre reason, pharmacies require a conditional use permit, kind of think, is this, do we want to go through a conditional use permit process for these marijuana operations? All right, the second option, and this one I like a little bit too, is the moratorium option. And a lot of communities have these in place and are using them. The statutory moratorium process is in the 35A63-220 and 3563-200. Which one applies depends on whether you're a code city or not. The process is the same for both types of cities. And basically, what you do to adopt a moratorium is, you put together an ordinance that says no pot in our jurisdiction. Within 60 days, you hold a hearing on this ordinance and, get comment on whether the moratorium or not is a good idea. Then you take it down to the Planning Commission for a final recommendation. That moratorium initially can be in effect for 6 months, or if you have a work plan, be extended to a year, and then you can extend it in 6-month increments. And the statute itself has no restriction on how often you extend that in 6-month increments. But there's the subsection B there's the issue of rolling moratorium liability, all right? The United States Supreme Court a few years ago in the Lake Tahoe area ruled that a moratorium down there that went on, I think it was like 3 years, and it went on for a long time, was violated the constitutional rights of the property owners down there and could result in takings liability because they couldn't do anything with their property for too long. I've seen a little concern in the written materials from the insurance attorneys and that kind of thing is we don't want these moratoria to go on for too long. And the courts have always, there's been suggestions in the court, that, for your typical land use situation, where you have a moratorium because you have to study a particular land issue, that kind of thing. A year is reasonable. When you go beyond a year, it's becoming a problem. I think for this situation, though, for pot zoning, you could probably justify it quite a bit longer. I mean, again, the insurance companies for the cities are real leery of moratorium. So if you're going to have a moratorium that's more than 18 months, talk to them and make sure that they'll back you and that they're okay with it. But the reason why I'm not super uncomfortable with the fact that one could go on for 3 years or not is when you're talking about takings liability, thou shalt not take property without just compensation. You're balancing essentially the public interest that's involved versus the burden on the property owner. And consider how that balance would work out when you're dealing with marijuana moratorium. On the burden on the property owner, it's like, well, they can't conduct a use that's illegal under federal law, and they could be shut down at any time if they actually started it. Whereas the public interest is you want to comply with federal law, and you need to see how the courts are going to rule on federal preemption. You want to see how the Kent case is going to go. You want to see how the legislature is going to deal with reconciling medical marijuana regulations with recreational marijuana regulations. And all that takes time. You know, the city and county just wants to, you know, do the right thing. And I think that's going to be very persuasive with the court. So, again, I think there's some people may disagree with me, but it seems to me you have really good reasons to extend that moratorium for a while. Of course, one of the benefits of a moratorium is you know the federal drug violations, because you're not allowing pot in your community. The wait and see, the reason for it, I've just gone through. You're going to be a pro-marijuana target with a moratorium, but one of the benefits of it is that I would think you'd be secondary to the jurisdictions to just adopt a complete ban. I mean, I would think that if some organizations are getting together who want to back a business license person who gets a permit denied, they're going to have a list of jurisdictions that ban it outright and go for those first. You might pick on the ones who are just waiting and seeing and may actually decide to allow it depending on where the law goes. So that's actually my third option, the permanent ban. I've kind of gone through those things. You have high code enforcement costs and in dealing with that as well, but that's you know, a minor issue, I think. Well, can be for some jurisdictions. Interim regulations, the same statutory process in adopting it as for a moratorium. You know, you can adopt it outright, and then you hold a hearing within 60 days, and you can extend it in you know, 60-day, or excuse me, in 6-month increments. The issue with that, of course, is you have potential federal drug violations, especially if you're issuing discretionary permits. The downside is there's you know, potential liability if you authorize something and then say it has to go away you know, when you change your interim regulations and adopt something permanent. And your permanent regulations, you know, the process there is it first has to go through the Planning Commission and then is adopted by the City Council. You got to hold at least one public hearing in that process. It has to go through. He said it takes time, and if you're worried about these, you know, the Liquor Control Board licenses coming out, and you need to act more quickly than that, you might want to go the route of an interim ordinance, or, you know, keep your ban in place. So with that, I'm going to end. This is a table that's at the MRSC website on medical marijuana, and it shows how different communities have dealt with dispensaries. And of course, now the general opinion is dispensaries are not allowed anyway, but collective gardens, you can see how much variation there is from community to community. And it's precisely because, you know, choosing between taking risks with federal law as opposed to local law, and then what the constituency wants, that's going to vary widely from place to place, and it's going to continue to do so. So, you know, good luck in playing Let's Make a Deal, and you know, I hope that you don't lose too much sleep over coming out with the right solution. It's going to be a challenge for all of us. All right, thanks again.
Thank you, Phil. In the interest of time, I'm going to skip questions right now. We're going to hold those for the end, and we're going to have Brennan Staley come up and as our final presenter.
Great. Thank you very much. So again, I'm with the City of Seattle. I'm a senior land use planner there, and I'm going to transition from some of the broad legal issues to some of the more nitty-gritty zoning implementation issues. First, just a couple of points of background. One, I think it's really important for people to understand that really what we're doing now is we're going from 2 marijuana markets to 3. We've had an illicit market for a very long time. We have collective gardens that have been established in the City of Seattle. We have over 100 dispensaries that are operating as collective gardens in a very legal gray area. And then we have a new licensed business pathway. And I think it's going to be, I think for a long time we're going to see a number of those markets existing. And it's going to be a real question about, depending on what each city does, to what extent each of them is going to survive. And just briefly on that, I mean, I think that everybody agrees that the licensed pathway in the short term will be more expensive to buy. But it's going to be a question of when does that kind of the premium of getting caught, obeying the law, will push people to do kind of the right thing and go through that market. Second of all, it's worth comparing this to alcohol. Obviously, every city already has this whole system and process. The state has a system and process for alcohol. This is clearly different, but there are a lot of parallels. In some sense, we're lucky that we don't have to deal with a lot of the bar and nightlife issues that come with alcohol, since that consumption element is prohibited. Lastly, I did want to dwell just a little bit on what we hear from applicants. One, we hear a lot that it's actually very hard to locate a business when you look at the 1,000-foot buffers, city zoning, when you look at the difficulties of getting finance, of dealing with landlords who don't want to be sued under federal law. There's a lot of obstacles, I think, for that. And I think potentially even in Seattle, we might just see a constriction in the market in the long term as people try and make that happen. So just to walk through the kind of key questions, which I'll kind of answer from our perspective. Is there a compelling reason to ban? Are your existing zoning regulations sufficient? How is indoor agriculture regulated? Should medical facilities be treated differently? Are existing development standards sufficient? And then also kind of a more nitty-gritty question, should marijuana businesses be a distinct land use? Are they already regulated by things, or do you need to separate them so you can really drill into what you want to see? So I'm going to talk a little bit about Seattle's approach. Obviously, we're very different than a lot of cities, but I think we have thought through a lot of these issues to date. The first, just kind of dwell on the kind of general approach, and I think what we did is somewhere between the do-nothing approach and the permanent regulations. An idea, basically, we want to treat it fairly similar to alcohol, as something that we don't call out specifically, but we deal with it through a lot of different ways. But then really address some kind of very specific issues that we're concerned about. And so first, we're going to regulate it. We're planning to, and I should point out also that the legislation that kind of puts this framework into place actually still is being debated by council. I'm talking kind of about the proposal that's going forward. It is still subject to a lot of discussion. First, that we are going to regulate it as under existing uses. Growing is an agricultural use. Processing is a food processing use. Dispensary is a retail use. And so we already have a whole set of regulations and use requirements in place, and we felt that those were actually pretty reasonable when combined with the state regulations about separation, et cetera, to regulate at a local level. But then we also did want to address a couple very specific issues that we were concerned about as a city. One, putting a size limit on the size of any indoor agriculture operation in our industrial lands. We care a lot about those industrial lands. They provide a lot of good-paying jobs, and we wanted to make sure, since this is a very intense money-making industry, that that it couldn't kind of outzone a lot of our industrial lands. And we're still kind of discussing what that size limit is going to be, somewhere between a prohibition in some areas to 10, 20,000 square feet, and maybe even as much as 50,000 square feet. And I know that the state is now considering also some of their own size limits so that this issue may go away. Second, we're putting in place some specific limitations for residential and historic areas. And what that is basically a prohibition on any business or residential unit having marijuana that exceeds the standards of an individual collective garden, the 45 plants and 72 ounces of marijuana. And actually, I think that we actually already have in place a lot of regulations that would take care of the residential one, but I think just because we've been operating in such a gray market, and for so long people have seen this as such a valuable thing that they could operate out of their home, we wanted to be just really clear about residential being inappropriate. I think in the long term that will go away as it becomes much more profitable to locate kind of above ground. And then also our historic areas. Seattle has a lot of greater propensity to be in a tourist zone, especially when you look at places like Pioneer Square. There's a lot of kind of character issues that we were really concerned about. We wanted to make sure that those didn't turn into kind of like a little Amsterdam areas, and so we have kind of specific prohibitions in those areas. The next point says that we allow individual collective gardens in all zones. Of course, that's not true. We're just not prohibiting individual collective gardens in all zones. So I think that's, again, the key to this approach is that we're kind of doing nothing, but then putting into place a number of specific limitations or prohibitions. We're never be in the place of actually allowing something or just stamping that that it's allowed. With the idea that you try and be consistent with what the state intended for the individual smaller scale operations, not the co-located commercial scale operations. And then one of the really big issues that is going on that I think Phil talked a little bit about is this question of will we require a state license for any marijuana use at some point, either now or in the future? This is a major question that we're still debating. I think we have a really tremendous concern that the state is doing a really good job of having standards for the licensed facilities, but the collective gardens operate in a gray area, which is essentially unregulated. And we didn't want to go that step of trying to create a whole separate licensing entity that did everything the state's going to do for a collective garden. And so instead that we want to push everybody to that license pathway. Some of the debate, though, I think is, we already have a lot of people who are operating in that pathway. We are hearing tentatively from people that probably half of those people who are currently the kind of medical collective gardens want to remain in that pathway. So we're hoping that maybe the state also might step in over the next year or two and kind of create a new pathway for medical. And so there's a little bit of question about what the timing on that is, but I think it is a kind of a really important element for people to talk about. And then lastly, relying on the state for all the buffer rules, development standards, advertising, security, and all I'll say on that is I think we took a really close look at the state rules and whether they seem to be meeting our needs, and we felt that the state did a really good job of getting into the real nitty-gritty of kind of all the important things, especially around security, which we are really concerned about. So just briefly, I just want to say on the kind of the overall legal approach. I mean, I think the idea here is that we're mostly doing nothing. If it meets our existing regulations, it's going to be allowed. But then putting in place some kind of additional prohibitions on things that we really don't want to see, so that we're not in the position of approving a license for a marijuana business, but rather we're stepping in when we think it is necessary. A couple other zoning issues I just want to touch on. One is the home occupations. Again, everybody's home occupation rules are different. Ours are fairly strict and have a lot of limitations on number of deliveries, advertising, the number of traffic. And in the long term, I think it's pretty clear that these businesses are not going to be able to make a profit operating out from somebody's home. But we have had concerns because of the profitability of this market in the past. People have been abusing those. And that's again why we took that standard of actually specifically saying anything larger than a collective garden is prohibited in a residential zone. Private clubs. The state does allow smoking in private clubs if no employees work in the smoking area. And so this provision has been used for cigars to create kind of, again, like a pseudo a business operation in which members pay money into a fund in order to occupy that room, either just to pay the cost of the room or actually to create to pay for a business. That is a concern that business model could be extended to marijuana. At this point, we've decided not to take any specific actions, but rather to monitor that really closely to make sure that they really are, being a private club rather than trying to operate as a business. A couple notes on permitting. One, I think that regardless of your approach, I think training of the counter staff is really critical. We found that the first businesses that came in that were open, immediately the counter staff would stop and say, "This just seems funny. I'm not going to give you any advice, and I'm going to stop." And so I think that it's important to, again, regardless of the approach, give that training so they understand they're all on the same page about what's happening. I also want to highlight that we've seen there's a very diverse background of applicants. And I say that in the sense that we have some people who are, more eager to do the right thing than anybody else you would see. I've given presentations to groups that say, please regulate us more. We need this to become a legitimate business. We really want to do the right thing. We've also seen a lot of people who have been doing this for 10 to 15 years without getting permits. And they're not only not used to that, but they're actually very scared. And so I think there's a pretty wide diversity of applicants who are going to come in. And I think it's important, if you are not banning, to be a little bit welcoming, because that process is difficult for permitting is difficult enough for anybody, but there's a lot of people who are very scared. And what I will say is that, as a city, we really want people to get those permits. We want to know where they are, but also, we spend a lot of time dealing with fires that have occurred from improper electrical, and so I think this is a really great opportunity to make sure these places are safe, that they're coming into the light, that thus following security measures that the state is putting forward, they're doing the right electrical work, they have the right egress, etc. There's a lot of small issues which I'll just kind of skip through really quickly. Grow lights have come up obviously as a specific issue. We found that they're exempt from the energy code as industrial process. Climate controlling has been an issue. A lot of people, obviously growing indoors, they not only are controlling temperature and light, but they're also controlling CO2, humidity. We found that kind of level of conditioning is also an industrial process, but because a lot of these are choosing to operate in warehousing spaces, that often a lot of new installation is needed because it's conditioning space. And then also there's a lot of converting of warehouses going on, from a kind of a cheap space, putting a grow operation, and that has the potential for treating other kind of access and other substantial alteration issues. So these can be tricky permits, and it's important, I think, to get these people to kind of do the right thing generally, come in early, understand, and get the permits. And then lastly, butane extraction is a method that's going to be used. I think they'll get a lot of the oils, or the DAB, as they often call it, and that may need fire permits as well. The last thing I'm going to talk about is our process for reviewing applications or license applications that are coming in. The first is that we already have a very developed alcohol process, and I think obviously this is an ongoing thing, but we're really looking at this as utilizing our existing process for alcohol because it works very well. And what that means is in our process, notices come in, they immediately go into the land license and standards inspectors as well as to law. The inspectors look for business licenses and payment delinquencies. Law passes it on to our law liaison attorneys in the police department, essentially the lawyers in the police department, and they bring the renewals to the advisory councils to look at the background and history of applicants and kind of gather all that information. And then lastly, the city actually uses, again for alcohol, the Liquor Control Board has a point system that they use for looking at applications. We found that actually using that exact same form is very helpful because it allows us, to have a legitimate framework for reviewing things, and it also allows us to have a kind of a good response to the Liquor Control Board if we, to use their language essentially if we see problems, unless it's a really extreme or unusual case for some reason. And then of course, if it's okay, we do nothing so as to not create any legal issues, and if it's not okay, then we file a complaint. And we found that it has worked very well. We suspect that it will work well for marijuana. But again, the idea being getting it down to people who have some local knowledge and having some process you can do that in a timely manner. A couple other major issues that we as a city are dealing with. One is public consumption. Obviously this has been less of an issue because it's been completely prohibited, but now that there's this new era, we're going to see a lot more people trying to smoke outside. We have been working with the police department to make sure we have a standardized approach like we have for alcohol. Generally that is first is a warning and second is action, and then some process for the escalation that is likely to occur. And then also we're changing our city laws to have a specific citation process so we don't have to use the state laws. That is really important because obviously the funds come to the city rather than the state. It creates an incentive to do it. And then lastly, I just want to dwell a little bit on zoning and police enforcement. I think that our first reaction was, well, this is great. We spend so much money on police enforcement. Trying to get street dealers to shut down, trying to make sure people aren't doing things illegally so they can cause electrical fires, and this is going to make that a lot easier. And I think that when you really think about it, this actually maybe causes, especially in the short term, for maybe a greater deal of enforcement than normal. One, there's still going to be an ongoing need to fight the illicit trade. It's likely to be cheaper than licensed marijuana for a while, and we need to kind of send that signal in order to get people to shift over. We're also, I think, you need to have an approach to dealing with collective gardens. Again, they're operating in a very legal gray area, and so how you want to, the state has unfortunately kind of left that decision to the cities about, how are we going to try and really make them stick to the state's definition that, or can they, co-locate and operate as a commercial business? And lastly, I think there's this question as new business come out of the darkness into the light, it is a question of, do we want to do something retroactive to make sure that since they definitely didn't get permits in the first place, that they're kind of getting retroactive permits to do the right thing. And so I think in the end, I think there's an opportunity for kind of reducing the impact on the city, but in the short term, there may be a greater need as you transition to this kind of gray period. Looking forward for a second, I think that there's a couple things that are kind of coming up that it's important to have on the radar screen. One, I think there's a great opportunity for the state legislature to move to reconcile the differences between the I-502 license pathway and the medical pathway. That's a big concern to us. And also, I think now that we're in this new age of kind of a bigger business and experimentation, we're also starting to see low THC marijuanas that actually have such a low level of THC that you really can't have any of the psychoactive, or you can't get high on them essentially, but you can still have some of the other things, the hunger relief, the pain relief, and so there's a real option to actually kind of create a little bit more of a fine line, or a blacker line, I guess, between what is truly a medical product and what is a recreational product, and to kind of separate those. So I'm going to turn it over for questions.
Thank you very much, Brennan. So thank you again to all of our speakers, and I'm actually going to invite our speakers maybe back up to the front table here. And we've got a number of questions that have been submitted, and I know we have more coming in from the web, and we've got some in the room as well. So we're going to spend the next 20 minutes trying to get through as many of those questions as possible. We're not going to be able to get through them all, but we are going to be recording any questions that come in, and we will be compiling a frequently asked questions sheet from those and getting that out hopefully later this week, early next week. So at least as soon as we can. Again, a reminder that this webinar has been recorded and will be available on our website later. The slides, the materials from our presenters, we will be getting posted on our website as well, definitely by the end of this week, perhaps sooner, depending on availability of staff. And then if for some reason you didn't get a chance to answer a question today, or excuse me, ask your question today, something comes up later, please feel free to email Brittany Still or Candace Bach here at AWC, and we will do our best to answer those. Or we're also going to be working with MRSC more in the future, as they are really a great resource for these sorts of issues. So also, Rick or Ellen, if you'd like to come on up. And for our panelists, you can stay at the table, and we will turn this, and it will be able to pick you up, and that way we don't have to have people coming up to answer questions. So Rick, I'll let you stand there.
I'll have Alan come up too if I need.
Okay.
Oh, you're going to read it.
I'll read the question so that everybody can hear. And maybe first I'll see if there's a question from anybody in the room. Yes.
So I heard a lot of comments about reconciling collective gardens and the recreational. How would you recommend doing that in a legal way, or in the least with the potential for liability? What would you recommend?
Well, let me speak for a moment to a budget proviso that was adopted in the budget this year that has the Liquor Control Board, the Department of Health, and the Department of Revenue bring recommendations back to the legislature in January to how to properly regulate medical marijuana. So this gets to the whole issue of having dual. I think someone suggested 3 marketplaces. You obviously have 2 dual marketplaces with medical marijuana. If in fact those dispensaries are being used by recreational users who can get access to the cards easy, then you see the fact that you can't have 2 parallel markets, one that's regulated and taxed heavily, one that's unregulated and untaxed. So I think we'll begin that work in the next month. Actually, there'll be a hearing on September 10th in the House Government Accountability and Oversight Committee, where we're going to lay out the schedule for what that looks like during the interim, a proposal that will come back to the legislature to try to figure out how to deal with that. Because obviously we want to protect the patients who use medicinal marijuana, but if in fact it's a large percentage of people that are using the dispensaries for their recreational use, we need to move them into the legal system. So I'm sure others might have, but that proviso that was adopted in the budget is the beginning of kind of getting to how are we going to deal with collective gardens, and how do I really qualify as a patient? The legislation that was discussed earlier before the governor vetoed it actually created a regulated system for medicinal marijuana that probably answers many of the questions and allows for registries where patients are truly cared for and have access to the dispensaries. But whether we're the Liquor Control Board going to be the entity that regulated, or whether it's the Department of Health, which maybe might be more appropriate, that'll be part of the discussion during the interim.
Does anybody else have a comment on that question? No, okay.
I guess I'll just say less from a legal standpoint that I think that it's both kind of a legal question and an enforcement question. That I mean, it will take, again, in Seattle we have over 100 of these dispensaries, and so it's not just question how you can do it legally, but also how you can get the resources in place to actually make that happen. I mean, because you're essentially talking about coordinated zoning, police, shutdowns if you're really going to take that approach. And so I think our thought has been, probably we're some kind of language that you have to have. Any marijuana that's not licensed is going to be illegal. But maybe some kind of timeline that gives people the chance to come into the right market, that hopefully would allow, if a new medical pathway, allow them to get into that pathway as well, so that both legally, but also we have the enforcement resources to get people to do the right thing.
I think too, it's also important to recognize the differences between collective gardens and business operations. I haven't studied the proposed Liquor Control Board rules super closely, but it seems like they require quite a lot of the business operations. Or if you have a producer, they're required to have video cameras and do all sorts of paperwork, and that really probably isn't appropriate for a small scale collective garden use for medicinal purposes. And obviously, as those laws are recognized, hopefully that'll be considered as well.
So a question from somebody, or actually a few people had a similar question, and it is, what happens if a daycare or other sensitive use that's subject to the 1,000-foot buffer moves in after a licensee has their state license and is operational? What's the Liquor Control Board's response to that? And then I think maybe from our city attorney planner panel, is there a different response from a city if there is a use that comes in after a medical or a marijuana business is licensed and operational?
Well, we probably use the same regulations we use for liquor. So if a school were to be built next to a liquor licensed establishment that's already been licensed, they would be grandfathered in. We would use the same issues with respect to the 1,000-foot buffer and the entities and the rest. So we wouldn't take their license away because a school decided, or a park decided, to show up next to the licensed premise.
Yeah, and if you have some separation requirements in your zoning code, they would clearly be grandfathered in as a valid non-conforming use, unless you had some weird amortization provision to require them to move within some reasonable period of time. But our vested rights are pretty strong in the state for that kind of thing.
I would just add, and I agree on the vested rights issue. However, I think there still may be an open question regarding the status of legal non-conforming use. There is some case law, obviously not dealing with marijuana, but that suggests legal non-conforming use must have been lawfully established when it first began. And if something is still illegal at the federal level, therefore the question is, could it still be lawfully established? And if that's the case, then I think perhaps you should lose that right under legal non-conforming use. So that's still one avenue that hasn't really been tied down.
Next question I think is for the Liquor Control Board. Will the Liquor Control Board be verifying the surveillance and security measures that are going to be required under the new rules?
We will, yes. So there'll be an inspection that will be done by enforcement, just as we do for our liquor premises, but probably a little bit more rigorous here with respect to these new licenses. But they will have to conform with the regulations on the security systems, the traceability model that we have. They're tying into that, yes.
Another one for the Liquor Control Board. When will the Liquor Control Board be notifying local jurisdictions about an applicant? Will that be before or after you've evaluated the 1,000-foot buffer requirements?
I'm going to let Alan and Becky.
Generally speaking, we'll probably follow a very similar model to liquor, in which one of the first things we do after receipt of application will be to notify the local authority and give them start the process of allowing their review and ability to comment. We're trying to keep as much of this process in parallel because of the requirement that cities have that they can be looking at their evaluation at the time that we're starting to process our applications. So we'll be very early on in the application process.
Another question about the 1,000-foot buffer. If the 1,000-foot buffer splits a parcel, will the operation be allowed in the part of the parcel that's outside of the 1,000-foot radius?
I'm not exactly sure what is meant by split a parcel.
So perhaps you have a large parcel with maybe multiple buildings on it, and the operation wants to locate on the back half of the parcel, say, that's outside of the 1,000-foot radius, but within a parcel that is impacted by the 1,000-foot radius. Would that be allowed?
I think one of the things that you will see in the rules that will be looked at by the board on September 4th is a further clarification of that 1,000-foot buffer issue, because we did receive several questions about that concept of how that 1,000-foot is measured. So I would rather kind of wait and say, take a look at that and see if that answers that question. I think it does.
Okay, here's a question that I think only perhaps a land use attorney or planner could appreciate. Is a site plan review permit a discretionary permit in your opinion, and then required for all new or very different commercial uses?
Well, I would say it depends on, how broad your criteria are. I mean, some site plan review processes in jurisdictions don't involve a public hearing and simply apply all the city's development standards, that are real rigid, parking X spaces per X square feet and that kind of thing. In that situation, your liability is probably minimized. But if you have a site plan review process that contains the criteria that this project will not adversely impact adjoining uses, and you have a public hearing and you're considering the impacts of the marijuana activity, your liability there is probably increased.
Yeah, I would say from our perspective that it's going to be very rare that any of the permits for these types of grow, processing, or retail facilities are going to be discretionary, that they're generally smaller ones, they kind of fall underneath all the thresholds. We're certainly not considering having any conditional uses for them, and they wouldn't generally meet most of the CEPA and other kind of discretionary thresholds.
A question maybe for the state, but also we'll see if others have thoughts on it. Could the federal government come in and seize state funds collected in violation of federal drug law?
There you go, Rick.
I suspect they could. Have they done that? Not that I'm aware of anywhere with respect to medicinal marijuana, so I don't see that happening. But if this trick question is, can they? I suspect they could.
Also along maybe similar lines, current medical marijuana operations often ask for donations. They don't officially sell their product, and so they don't collect tax on those sales. How will that situation be considered by the Liquor Control Board as for application compliance? Will they be considered out of compliance because they've not submitted taxes, or will they be considered compliant because they've been collecting donations not subject to taxing?
Well, if they're not subject to taxing, then it wouldn't be an issue, because the attestment is that you have sales that are taxed that have to be collected by the Department of Revenue. So the only thing the Department of Revenue is going to tax is a sale that occurs, whether it's legal or illegal.
One of the really big questions that keeps coming up time and time again is where a city has a business licensing requirement that says you have to be in compliance with all federal, state, and local laws. Can that be used to effectively ban marijuana operations?
It's certainly possible, and I think for cities that also have that as a zoning requirement as well, it really gets down to the heart of how legal is legalized marijuana in the state of Washington. And some people have argued so far that this is fully legalized because it's authorized by the state. Some people have said it still doesn't quite rise to that level because if it's unlawful under federal law, it can never be fully considered legalized, and therefore it would be within the purview of the city to decide that it could be regulated or prohibited out that way. Because you wouldn't have the same constitutionally protected rights that you would for a fully lawful business.
I think this question has come up a number of times and will continue to come up, and it will be litigated at some point. This is let's see, starting through my questions. A question for Seattle, and maybe just a clarification. Is Seattle allowing medical marijuana dispensaries, and if so, under what authority?
So maybe a couple of questions there. One is it allowance, or are we not prohibiting? We make a point of never saying we're allowing them. So I think that our approach is that we are not going to make a regulation that makes a distinction between a medical or recreational marijuana. And that's partially because we just don't, as a city, have the ability to to enforce that point, to track it through its process to find out if the person has a card and if that card is legitimate. So we're not making a distinction between medical and other. And so in the short term, we're going to treat them all the same. But I think looking towards at some point, essentially requiring licensing of all businesses at some point. Again, allowing probably an interim period for people to come into compliance. But yeah, so in the long term, the expectation that everything is going to be licensed. In the short term, not getting into that distinction.
Another question about the federal government reaction. Is anyone aware of the federal government actually denying grants or demanding repayment if drug policies connected to those grants are violated?
I haven't heard anything.
I don't think that we've heard anything either specifically. There has been advice to cities that receive federal dollars to make sure that your personnel policies are up to date and current, and that you continue to comply with the federal government's Drug-Free Workplace Act as part of those grant requirements. So it may be something where you have to look at your individual grant, make sure that you are indeed complying with those requirements. Let's see, I think we have time for maybe just a couple last questions here. And I think this is sort of a question comment. Even a change of occupancy for existing structures requires a permit. So doesn't that mean that the jurisdiction has a hand in the recreational marijuana regulation already?
Yeah, I think that there are going to be some permitting issues that are going to be unavoidable against since the change in uses. It doesn't involve a lot of inquiry into the illegal aspects of the business. You're in the spectrum, that's on the lower end of liability risk.
Yeah, in general, I mean, we treat most of the standards for a change of use the same as for establishing use in the first place. And so I think that in the end, it's going to be the same issue is going to kind of come up for either of them.
Okay. And maybe any questions from the audience here before we wrap up? Yes.
Just confirming our understanding on the definition of daycare for persons with 1,000-foot trigger, the rules. The proposed rules talk about, it mentioned daycare center, which in our codes, I believe state law as well, is 13 or more children. Whereas the definition within the 502 proposed rules is more inclusive of smaller centers and also of preschool, essentially. And we're assuming the latter, the more inclusive definition is what you would map under, but I wanted to confirm that.
The question is about the definition of daycare center and what definition the Liquor Control Board will be using.
Well, and I have to go a little with my recollection because I don't remember exactly what the words say, but I think that we are trying to be as inclusive as we can as to those that are, and the resource we're using is the Department of Early Learning's, regulated entities that are allowing daycare. That's really kind of our baseline that we're utilizing.
And I think actually the definition actually now references a WAC citation, right. So there is a very specific definition that now is pointing to in the code.
One last question.
Phil, you argued, and I think I forget your name was Seattle, the CUP has a higher level of liability because there's a great deal of discretion involved. But isn't the fact that now the Liquor Control Board is so thoroughly enmeshed with legalization from a state perspective, that they're really by far the bigger fish from federal enforcement and federal liability?
Yeah, no, I would agree with that. And, I kind of made a joke about that first picture of the DEA and arresting somebody from the Liquor Control Board. But I think, yeah, because they're directly addressing the illegal aspects. If anyone is taking a risk there, it's them. And, I hope if they get arrested, they don't get fired for having a criminal conviction on the background. That would be really ironic. But, no, it's again, it's the more involved you are in the illegal aspects, the greater your risk. And yeah, the Liquor Control Board is at the top of that spectrum there. Except for, there's also there's an Oregon case that came out about, well, I referenced a little bit about, returning the marijuana to back to the person who owned it from law enforcement. That is like you're touching it and you're actually distributing it. You're personally there. That's the ultimate source of liability. And I can see why the Oregon State Attorney General's office was so concerned in that situation.
Thanks.
Well, thank you all, everybody who's joined us on the webinar today, and an enormous thank you to our speakers and panelists today. Really appreciate you all taking the time to come and to put your presentations together. A great appreciation to the Liquor Control Board, who has, this is their second webinar with us, and they did 2 of our conferences, so really appreciate their willingness to outreach to cities and local jurisdictions. So again, thank you for participating today. We will be posting this information on the website later this week, and with that, we will be closing today's webinar.